All right, so this is a special motion to dismiss, which is denied. They can move for summary judgment upon completion discovery. Let judgment be entered. Very exciting. All right, Nick. This is a case for defamation as well as both intentional and negligent infliction of emotional distress. Quest claims that Rekieta made false defamatory statements about him over the course of 6 videos between October 2022 and January 2023. He asserts in these videos Rekieta insulted him using coarse language and slurs, and that Rekieta called him the P word. Rekieta moves to dismiss on the basis of Colorado's anti-SLAPP legislation, claiming that Colorado law is more substantially related to the Quest claims, and the lawsuit is frivolous, intending to chill Rekieta's speech. Both Quest and Rekieta have submitted flurries of evidence, almost all of which indicates they were engaged in a vulgar online shouting match. Both have called each other abhorrent names and made rude jokes at the other's expense. However, very little of the evidence on record relates to an actual claim of defamation, intentional infliction of emotional distress, or negligent infliction. Even so, claims of P word are serious and treated by Minnesota courts as a matter of defamation per se, which is not atypical, by the way, because you are making a claim about someone's sexual virtue, which is a defamation per se kind of issue. So that's not unusual. Further, while there's currently a lack of evidence to support the claims of intentional and negligent infliction of emotional distress, it's improper to grant summary judgment here because the window for discovery is yet to close. Therefore, the motion is premature. Okay, so we're moving for summary judgment, and it's just early. While summary judgment is improper at this time, it may be reconsidered once they have the ability to develop the record. Okay, so is this a motion to dismiss or a motion for summary judgment? Well, they say it's a motion to dismiss. And then so they move for both summary judgment and dismissal? All right. Factual background. Both parties have achieved relatively significant success as public figures on the internet. All right, Nick. I mean, fair enough. So the court thinks you're a public figure. Okay. I don't know that's necessarily a give me, by the way, but this court thinks it, but fine. Quest received attention for creating, directing, and publishing videos online through his YouTube channel under the username Montagraph. He also goes by the online username of October Reigns. His content ranges from potentially satirical and ridiculous to unsettling. So the court thinks that Montagraph is ridiculous at times. That's funny. Rekieta is an attorney who also produces content that discusses topical legal issues in the form of pre-recorded videos and video streams. Rekieta describes his content as commentary that aims to be both informative and comedic and compares it to late-night shock radio. Yeah, definitely more so than me, that's for sure. Nick has a much more wild appetite for such things. While creating this content, Rekieta drinks, employs coarse language, slurs, and makes off-color jokes. Quest admits that Rekieta's content focuses on hyperbole and commentary. Yeah. In the amended complaint, Quest identifies 6 instances in which he alleges that Rekieta made defamatory statements. First, he alleges that Rekieta was a guest on a live stream in which he made various false statements of a sexual nature about him, which would potentially be defamation per se. Quest additionally claims that Rekieta appeared in a video published in October in which he accused Quest of P-word, asserting that he enjoyed doing P-word relating things. In the same video, Rekieta say that Quest should probably be shot in the fucking head, and then calling him a P-word something. Yeah, that's okay. Quest further claims that Rekieta appeared in a video published in October in which the host presented an image of Quest with guns pointed at him. Okay. In another video published in October, Quest asserts that Rekieta accused him of making a snuff film involving a minor child in which Quest threatened the child both with abuse and violence. In a 5th video, Quest claims that Rekieta referred to him as R-word and challenged him to file a lawsuit stating that Quest's reputation was so poor there could be no damages. So defamation proof is the idea, which, is an affirmative defense, I suppose. So the idea is that his reputation is so bad, he literally can't be defamed anymore, which, is a possibility, to be sure. I don't know if it's true here or not, but it is legally at least arguable. Okay. Finally, Quest claims that Rekieta further referred to him as an R-word in a video published in January. Quest alleges that these statements made by Rekieta on these 6 occasions injured his reputation and character, so as to negatively impact his relationship with others in the community. Quest does not provide specific examples of this injury, although that's not required at this stage, of course, if it's defamation per se, because you don't have to allege damages. That's the nation what makes it defamation per se. The brief in support of the special motion to dismiss admits that he referred to Quest on these various occasions as various terms. He doesn't dispute that he claimed that Quest directed a snuff film that was named Little Piggy and the Umbrella Man, which he starred alongside a minor child. Okay. I don't know anything about that. That is well outside my knowledge base, so I have no information to offer as to factual basis on that. On the IMDb page for this film, Montagraph is listed as director and actor playing an R word. In October 28, 2022, Rekieta addressed Quest directly, stating that he has an image problem. Additionally, he referred to past statements regarding the potential P word, saying that kid stuff was joke stuff, and a reasonable person could form the opinion that Quest is a P word based on the movie Little Piggy and the Umbrella Man. I offer no opinion as to any of this. I haven't seen the movie. I don't know much about Montagraph. I have no opinion and no basis in fact to understand any of these things. This is well outside my knowledge base, and I don't want to know. I have no interest in learning that, to be quite honest. So I'll just note that I don't know. Rekieta brings the special motion to dismiss under Colorado law, anti-SLAPP legislation that aims to encourage and safeguard constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government. Essentially, the law aims to discourage meritless lawsuits that would otherwise discourage individuals from participating in free speech and public life. Pertinent to this case, the law protects defendants who make any written or oral statement of writing made in a place open to the public or public forum in connection with an issue of public interest, which that last part is sort of legally operative, right? Because we're talking about stuff that would be subject to the elevated standard of defamation. So we're talking about what would be like public figure. So we seem to be talking about like public interest in that same vein. So if it's in that higher category of speech, other conduct or communication furtherance of the exercise of a constitutional right to petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. Again, this is legally operative language, like public interest, public issue, public figure is all things that kind of go together in the same breath when you're talking about this sort of thing. So normally if you're thinking public figure, public interest, public issue, you're thinking to yourself, you need recklessness. And Colorado says in that situation, not even reckless will do, apparently. Further, the statute, well, I don't know if that's true or not, but that's at least the domain of stuff they're talking about. Further, statute provides the court must determine whether the plaintiff establishes there's a reasonable likelihood they will prevail. There is scant law addressing the motion analysis. One trial court provided a framework for addressing the motion and adopting California law due to the similarity between Colorado and California, which is okay in the first instance. Colorado is free to inform its law by parallel to other laws, right? That's what we call informative precedent, right? It's informative. Colorado can ignore it or can look to it or can adopt it as it pleases. So a Colorado court apparently trying to figure out what the hell this language means looks to language in California. It's like, okay, the language in California is similar, so I'm going to adopt this California decision and go from there, which, fair enough. That's a lot of how courts think. Yeah, fair enough. In the analysis, the trial court engages in a two-step process. First, the court decides where defendants made a threshold showing the challenge cause of action is one arising from protected activity. If that, then it determines whether the plaintiff has demonstrated probability of winning. And this is also, by the way, and it's worthy of note here, this is from some district decision in Colorado, which also is not binding authority even in Colorado. Because a trial court, unless Colorado says otherwise, and I doubt it does, trial courts do not provide binding authority because there's no one to bind. It's a trial court decision, right? So, and also trial courts are not even bound by themselves. So they can issue inconsistent decisions from case to case, right? Unless you have a decision from the Court of Appeals, right? Decisions from district courts are not precedential or not binding precedent. So they're informative even as to Colorado. So they're like this is tenuous, might be another way of thinking about it, right? So it's like, so the court in Minnesota is trying to determine what Colorado law, and Colorado law is thin. So that's not a great position for the Minnesota court to be in, because the Minnesota court, to the extent it's applying Colorado law, is forced to apply the law that Colorado would apply. Minnesota doesn't have any power to determine Colorado law. Colorado has power to determine Colorado law. So Minnesota has to try to figure out what the Colorado courts would do. In the absence of anything, not a fun position for a court to be in. Because, like, let me put aside the Minnesota books and open the Colorado books, but there's nothing in the Colorado books. So, not a great time. And the only time the Colorado books seem to be open is, let's open the California books. So am I opening the California books? Is that what I'm doing now? I feel for the court a little bit in this position. All right, Rekieta admits even if this court were to apply the law, which is a whole nother thing altogether, because what Colorado law is and whether it should apply here is a separate issue, by the way. So even if we decide that it should apply, first of all, what the hell is it? But then does it apply? That it would be equivalent to a motion for summary judgment, which, yeah, or a motion to dismiss, take your pick, either way. Summary judgment is proper if there's no issues of material fact and the moving parties entitled to emotional judgment. In considering for a motion for summary judgment, a court cannot weigh on the evidence, make credibility determination, or attempt to determine the truth. Sounds about right. To defeat a motion for summary judgment, the opposing party must set forth showing that there's an issue for trial, and the court must view the evidence in the light most favorable to and making all reasonable inferences from the non-moving party. Yeah. Correct me if I'm wrong, by the way, and maybe I'm speaking out of turn, but hasn't Rekieta previously expressed doubt about anti-SLAPP laws and their legal viability in the first instance? Because I could be wrong, and maybe my memory is failing me, but I was under the impression that Rekieta didn't believe in anti-SLAPP laws, that he thought that they were invalid. And am I having a brain fart moment? Because I was under the impression that Rekieta didn't believe in anti-SLAPP and thought it was unconstitutional. So that doesn't, yeah, I don't, that seems hypocritical. That seems hypocritical to some degree. If Rekieta believes that anti-SLAPP is invalid, then he doesn't have to invoke anti-SLAPP. There's nothing forcing him to invoke it. He doesn't have to invoke it. If he really truly believes that anti-SLAPP is invalid, why is he trying to invoke it? Shouldn't he have the conviction of his own principles and be like, I don't really believe in this? So why is he he's trying to invoke it for his own benefit, by the way. That's what the problem is, right? If he were representing a client, I would totally get it, right? Because he's representing someone else and wants to do the best he can for that client. So I would totally get it if he was representing someone else and invoking anti-SLAPP for them, because then he would be like, I don't agree with this law, but it's in the interest of my client and I have a duty to my client. But here his only duties are to himself, and he can ignore it if he wants to, right? So if he doesn't believe in it, why is he invoking it? Why is he invoking the protection of something he doesn't believe in? Seems a little bit problematic. Yeah. If the law allows it, though, why not use it? Because he doesn't believe in it. He didn't write it, his lawyer did. That's a fair point. That's a fair point. Fair point. His lawyer represented it. Okay, so question is, did he go to his lawyer and say, I don't want you to invoke this? And his lawyer said, no, I'm going to invoke it anyway, which technically can be a thing the lawyer could do. So is Nick saying that my lawyer is doing this over my own protest? because technically speaking, his lawyer could do that ethically. A lawyer's duty is to further the ultimate goal of the client, but the lawyer's strategy is to the client. So technically speaking, Nick could go to his lawyer and be like, I'd like to not be liable for defamation. And be like, I understand that. My goal as your lawyer is for you to not be held liable for defamation. That is my goal. And then Nick could say, I don't want you to invoke anti-SLAPP. And his lawyer can be like, nah, I'm going to invoke anti-SLAPP. Right? If you don't like it, fire me. And he can do that. That's ethical for an attorney to do. That's ethical. The client sets the goal, not the means to the goal. So strictly speaking, technically speaking, Rekieta can say, my goal is to not be sued for defamation. And lawyer said, great, you're the client, you set the goal. You want to not be sued for defamation, I agree. And then he can go to the lawyer and be like, I'd like you to not invoke anti-SLAPP. And the lawyer can be like, nah, fam, I'm all about the anti-SLAPP light. Get bent. So my question is that what happened? Did Nick go to his attorney and be like, you know what? I just don't believe in anti-SLAPP. It is not something I believe in. I think they're unconstitutional. I don't really agree with anti-SLAPP. I know the courts say that there's anti-SLAPP, but I think the courts are full of shit. And it's not something we have to invoke, which is true. We don't have to invoke it. And I want you to not invoke it. I know it's something that could further my case, but I don't want you to invoke it because I don't believe it. And the lawyer went like, nah, fam, I'm all about that life. Screw you. Is that what happened? Does Nick have a moral problem with this? And if not, why not? Why doesn't Nick have a moral problem with this? Why is Nick's position being, I really didn't want to invoke the anti-SLAPP. I really wish my attorney didn't do that, but he's, really, really good. He's really, really good. And I really, really wish he did. Oh, damn it. I really wish he didn't do that. Or is Nick okay with this? So, and we're back to a hypocrisy position. Incidentally, for what it's worth, why don't I ask Nick? Why don't I ask him directly? Well, Michael, not that it's any of your business. And by the way, thank you back, Andrew Son, for being here once again. But this is my first time reading it cold. So I guess I will ask Nick at some point. But I'm asking the question because I'm reading it cold and reacting to it as one does. Also, go fuck yourself. We don't want you here. Yeah. You think his position is that the law, as long as it helped me, why not use it? I'm not sure that that's fully tenable as an ethics position. Because what do you really believe in? Like, what do you really believe in? So you don't really believe in anti-SLAPP, but as long as it's there to help you, you'll take advantage of it. It's like, then I'm not, okay. That seems ethically questionable. I have questions. That seems, yeah. Nick doesn't agree with the decision to try to use it, but acknowledges it would benefit him. Then I think if that's true, then I think Nick is being a bit of a hypocrite. If Nick really believes the Colorado law is wrong and isn't going to his attorney and be like, I don't want you to use the Colorado law because I believe it's wrong, then then he's willing to put his sides for his own convenience. Principles don't matter very much if you're willing to put them aside for your own convenience, right? Principles are principles. You either believe in it as a principle or you don't. It's like, yeah, it's a principle, but when it benefits me, though, right? This is the problem of so much hypocrisy. This is the problem of so much problems on the left, right? This is the problem of a lot of progressive thinking. It's like, this is a problem because I see a lot of left-leaning people where, at least in my opinion, they don't apply principles when it's convenient to them. They don't really have principles, right? The principles only exist as a power tool, right? And I've seen this when it comes to feminism. I've seen this when it comes to trans rights issues. I've seen this when it comes to any number of issues, freedom of speech, any number of issues on the left, right? It's like, I really believe in it. I really believe in it, except when it comes and applies to me, then I don't believe in it anymore. You see this in California, for example. Yeah, we want more housing. We want more housing for the homeless, but not like that. It will decrease my property values. We want more rights for this, but not like that. It will hurt me in this way. So, hypocrisy is, a real problem. And to the extent that he is taking advantage of something he doesn't believe in, it makes you at least question whether or not he really believes in it in a principle, right? Do you really believe in this as a principle? Or I suppose maybe you've re-examined your principles. Maybe he's changed his principle, which is also fine, by the way. That would be a way to resolve the tension. Now that it's come, but you see, all right, yes, like, yeah, now that I've seen the light, I understand. But I'm as a philosophy guy really attracted to Kant, right? I like Immanuel Kant, and I think Immanuel Kant kind of goes too far in the extreme, but I kind of agree with him. It's like Immanuel Kant says, among other things, that there is no ethical position except a position which you can maximize without contradiction. The only thing that's ethical is a position that you can take and apply it universally, categorically. Categorical is the only ethics. And so I think he takes this to an extreme, but he I think he has a very strong point. And he might even be right in the extreme, but in the other extremes it gets very, very uncomfortable. When you really push Kant to the absolute limit, which Kant, by the way, is very clear that he wants to be pushed to the absolute limit. So it's not like straw manning him. Kant wants to be pushed to the limit. It's very clear he does. But when you push him to the absolute limit, it does become really uncomfortable. But like, this is not really compatible with Kantian philosophy, right? You can't really say, I don't believe in it, but I'm going to invoke it when it's convenient for me. Because now you're violating your principle for mere convenience, which Kant definitely would repudiate. Kant's over here like, you can't lie to the Nazis when they knock on the door asking where the Jews are. That's how far Kant goes. Because Kant's like, it's wrong to lie. And someone asked him in his own time, by the way, they asked him in his own time, like, what if a murderer comes to the door and demands to know where a person is, and it just so happens that person is currently in refuge in your house? Can you lie to the murderer knocking at your door who wants to know where the guy is, and the guy is currently at your house? Can you lie to that guy? And Kant said, no, you can't lie to him. That's how far Kant wants to go. Okay. So he's definitely not going to say it's okay if, it's merely a little inconvenient and personally uncomfortable. He is not employing a Kantian ethic. Yeah. Kant, K-A-N-T, Kant. Immanuel Kant, that's his name. So yeah, so there it is. I would respectfully suggest that Nick is in tension with Kantian ethics. Both parties acknowledge that Minnesota previously had an anti-SLAPP law that was found to be unconstitutional, which is presumably a position that Nick likes. The court in a prior case explained that Minnesota's anti-SLAPP statute cannot be applied in a manner consistent with the constitutional right to a jury trial because statutes requiring pretrial factual determinations require to step into the role of the jury. Now that Minnesota has found its own anti-SLAPP law unconstitutional, Rekieta appeals to Colorado law. That's Nick is my friend, and I hope will continue to be my friend after this. I really do. But that's a little ethically questionable, my friend. If you really believe that these laws are unconstitutional, unless you believe Colorado's law is constitutional for some reason. So if you believe Colorado's version of this is constitutional, then, okay. You'll have to explain to me why Colorado's version is constitutional and Minnesota's laws isn't, I guess. But if you believe it's constitutional, then I let you off the hook. You'll have to explain to me why, though. But if you believe these are unconstitutional, that one law was found unconstitutional, now you appeal to a backup because it's convenient, though. I have some problems here. I have some problems. I might have to have Nick on and challenge him because I don't know what. Yeah, this seems questionable. In a case where the relevant law is in dispute, the court must employ a choice of law analysis to decide which to apply. Fair enough. When deciding choice of law issues, the district court sitting in diversity generally applies the choice of rules of the forum state, which is true. Fair enough, yes. In Minnesota, the first step of resolving the conflict is to determine whether choosing the law of one state over another would be outcome determinative. In this case, because Colorado has an anti-SLAPP statute that provides immunity, choice of law is outcome determinative, which you know. And then they say Minnesota law applies. Once a conflict is found, Minnesota courts evaluate 5 conflict choice influencing factors: the predictability of the result, maintenance of interstate and international order, simplification of judicial tasks, advancement of the foreign government's interests, and application of the better rule of law. These factors are not overwrought rules, but rather tools. While prior opinions may be helpful, the court's obligation is to be true to the method rather than seek superficial analogies. Fair. First, predictability of results embodies the idea that litigation on the same facts, regardless of where litigation occurs, should be decided the same to avoid forum shopping. Also fair. However, this factor applies primarily to consensual transactions where the parties desire advance notice of which state law will govern. While it's possible forum shopping occurred in this case, with Quest choosing Minnesota as a forum state due to its anti-SLAPP, well, also Nick lives there. So it is a case, it's a court of general jurisdiction. So could Quest sue Nick in his home state? Questionable. Questionable when it comes to personal jurisdiction, right? So Quest, if he tried to sue him in his home state, Nick would be claiming personal jurisdiction, one would think, and Nick would probably be right. So Quest, being somewhat smart about it, says, let me sue him in Minnesota because it solves the jurisdiction issue. There is no agreement or anticipation of further relationship. The parties did not voluntarily associate. Instead, they were thrust in this conduct through public discourse. The favor applies applying Minnesota law over Colorado. Second, maintenance of interstate order concerns where application of one state's law would be manifestly disrespectful for another state's sovereign. Evidence of forum shopping or application of Minnesota law would promote forum shopping, which indicates disrespect. In this case, applying Minnesota law could certainly incentivize forum shopping, allowing plans from states with anti-SLAPP to file in Minnesota. Since Minnesota found its anti-SLAPP unconstitutional, defendants do not have statutory rights to chill the exercise of speech. If plaintiffs were attempting to intimidate defendant through legal action, Minnesota would be preferable. In this case, the factor falls to Colorado. The third factor is often considered insignificant because courts can easily apply another state law as their own. Yeah, that I tend to agree with, right? It shouldn't be that hard, you know, as long as the law is defined. If it's not defined, it becomes harder. But, you know, it shouldn't be that big a deal for a Minnesota court to apply a Colorado case because, you know, judges read decisions all the time. It's not like, you know, Colorado isn't that foreign. Although the case is insignificant, it applies to Minnesota because obviously a Minnesota court is going to be a little bit more familiar with Minnesota law. Fourth, advancement of a forum general government's interest involves analysis of where choice of law would involve significant forum state. Factor ensures that Minnesota courts are not required to apply laws or rule inconsistent with the concept of fairness and equity. Applying Colorado here would contravene Minnesota's interest in fairness and equity. It isn't that Minnesota has never enacted anti-SLAPP, it did, but we decided it was unconstitutional. This isn't a case where another state's law can fill in a void because there is no void, right? This is something Minnesota's decided doesn't work for us. Minnesota courts have spoken clearly that the anti-SLAPP is unconstitutional. As such, where it would require a pretrial factual determination. As such, Minnesota has made a determination regarding state interest that anti-SLAPP laws are suspect. And so Colorado's law might be in violation of our Constitution, and it's our Constitution in our state. Finally, the fifth factor is irrelevant. Plus also, although not mentioned here, this is the state in which Nick lives. So Nick is being judged by his own state's law. So how unfair can that be, right? Nick is being sued in the state in which he lives. So there's no problem with fundamental fairness. You know, if anything, Quest is at a disadvantage. So unmentioned here, yeah. Nick is not entitled to summary judgment. Regardless of other vulgar names, the accusations of P word are among the most valid claims because they're defamation per se. They can be, for sure. Statements are defamation per se if they falsely accuse another person of a crime, having a loathsome disease, or unchastity. All that stuff, yes. Following the rule, courts have held that statements accusing a person of serious sexual misconduct are defamation per se. In determining defamation per se, the court must analyze whether a reasonable person, this is key here, so pay attention. In determining defamation per se, the court must analyze whether a reasonable person in similar circumstances would understand the statement as making an accusation or imputing serious or similar misconduct. So this part is key, because you can make a statement. This is incidentally like key both ways. So you can make a statement that appears to be a statement of fact, but not understood as a statement of fact, right? So if you just read the transcript, as it were, it would appear as a statement of fact, but based on other statements, based on other surrounding context, based on tone of voice, based on other things, it would not be understood as a statement of fact. So you can have something that superficially appears like a statement of fact, but would not be reasonably understood as a statement of fact. Another example, by the way, of this would be where the statement is so hyperbolic that no one could understand it as a statement of fact, right? It's so crazy, so absurd, no one could understand it as real, right? So that's another example. A statement that seems superficially like a statement of fact, but is so hyperbolic, so over the top, that no reasonable person would understand it. So that's one example. Another example is where overall context makes it clear it's not intended as a statement of fact. And you can also have the exact reverse of that. You can have a statement that appears to be a statement of opinion, but is in fact a statement of fact because of overall context, right? So it's not enough to say, well, merely in my opinion, person X is Y, right? In overall context, that might be understood as a statement of fact. So this is really key. Would a reasonable person understand the statement as making an accusation of fact, namely imputing criminal serious misconduct? So yeah, that's really important. Courts go beyond this, however, stating, we hold that in almost every circumstance, a reasonable listener would believe that calling a person a P word imputes serious sexual misconduct or criminal activity. Which, fair enough, right? There are some circumstances in which you would not understand it that way. But, the courts are thinking that, being labeled a P word is particularly dangerous to one's reputation, which, there's not much worse in this world than being accused of being a P word. I think, that's pretty reasonable. So it's a pretty charged word, as one would anticipate. So is there some situation in which a reasonable listener would not understand it to be a statement of fact, or would understand it to be so hyperbolic in context to the person or other context does not apply as a statement of fact? Yes. There is some situations out there on the edge, but not so much in most situations, because most of the time it's understood as a statement of fact, or would be understood as a reasonable listener, the reasonably prudent, ordinary person, the man off the street, what would they understand? They could understand it as a statement of fact. The reasonable person standard in this question is the context of fact, which, fair enough. Ask a jury whether it was intended that way. How do you know? How do you know if a reasonable person would understand it? Ask a reasonable person. Ask 12 reasonable people. That's how we typically do this. Even though Rekieta acknowledged in this video that the statements were joke stuff, the strong language of case law supports construing the actions of P word as defamation per se. In almost every circumstance, a reasonable viewer would understand. Yeah. So again, like, it's not merely enough for the disclaimer. This is kind of like what the court is talking about, right? It's not merely enough to say, this is my opinion. It's not merely enough to say it's a joke, right? Because you can imagine, like, we're not going to just let someone off the hook with a disclaimer, right? Oh, this is just a joke, just joke, but just a joke, right? Unless you would understand, right? It's not enough to say the words, it's a joke, because you could imagine someone not interpreting as a joke, or their statement, it's a joke, to be itself the joke. But the statement's really true. And which of those realities are you in is a statement of fact. So all that stuff makes sense, right? So we, as a matter of policy, are loath to dismiss this out the gate. We, as a matter of policy, understand this word to be particularly loathsome. We, as a matter of policy, are loath to just simply set someone off the hook because they simply said joke stuff. So there is more here for a reasonable jury to potentially do. So that makes sense. That makes sense. Was it said with malice? Well, I don't know. And that gets into whether or not he is a public figure or not, which the court has at least teed up the possibility that he's a public figure, but I'm not going to take a position right now as to whether or not either of these people are public figures. I'm not going to take a position on that right now. So you might also have to prove malice, which, you know, means either Nick knows it to be a lie, which seems impossible, or he recklessly disregarded the truth, which is difficult to prove. So I'm not sure whether the elevated standard is required here or not, but the court has at least teed open the possibility that it's required. So we'll move on for the moment. In Minnesota, emotional harm resulting from defamation requires there be some reputational damage. True. That's fine. Emotional courts have exercised historic caution recognizing emotional distress claims, and emotional damages are not compensatable absent harm to reputation. In short, there's what reasonable person would choose to live in Minnesota? We'll let that go by. In short, there's reputational damages prerequisite to emotional damages and actions for defamation. At this point, Quest has not shown reputational damages, which, you know, he doesn't have to prove in the first instance because, again, defamation per se. Well, yeah. The only evidence of reputational damage is a video supposedly showing Rekieta devotees following him. The video, however, does not show a person trailing Quest. It does not contain evidence the person had any connection to Rekieta. It doesn't even show Quest. Well, that's not very helpful, is it? The lack of evidence of reputational harm at this point of litigation, however, may be cured through discovery, which is let to conclude. So the court's like, yeah, there's not any evidence right now, but I'm going to let this press on to discovery, which, fair. The motion for summary judgment is premature. Adequate time for discovery is essential to show that the claims are not unjustly thrown out before they had a top ability to produce evidence. As a general rule, summary judgment is only proper after non-movement has adequate time for discovery. In the present case, they opposed summary judgment on the ground, claiming the motion is procedurally defective, and summary judgment could not be supported at this stage of litigation because the factual record is not adequately developed. This is correct. Although Quest does not yet provide substantial evidence of finding damage, there's a possibility that he might be able to. You know, fair enough. The court wants to let it go to discovery and see what he can turn up, and then be like, if there's no evidence here, the court can say there's no evidence here. But he's like, you know, it's a word that is particularly charged, and so we'll give you a little bit more opportunity to find it. Makes sense. Although Quest does not provide evidence as of yet, there's a possibility he could before the window of discovery. The accusations of P-word were severe, even if made with comedic intent and tone. These are a type of accusations that would inspire anger, distrust, and negative consequences. Further discovery is conclude summary judgment's improper. That makes sense. That makes sense at this stage. The court could have gone the other way, I think, to be fair. But, you know, this decision's also unreasonable, or possible, also reasonable. You know, what's interesting here, by the way, as a matter of, like, just talking about it, like, you know, the court could have probably gone the other way and probably been within the bounds of discretion. And that might be something that makes people a little bit uncomfortable at times, but, you know, there is a matter of judgment here, and courts of appeal are loath to overturn trial courts, you know, in the absence of clear error or, you know, abuse of discretion. So if the court went the other way, the Court of Appeals probably would uphold that too, you know, to be quite honest. So it's like, well, it's a judgment. It's literally a judgment call. And the judge thinks there's enough to go through, and that's probably correct. And if the judge went exactly the opposite way, that'd probably be correct too. It's the question, like, from an appellate posture would be like, basically, is this so absurd that it can't stand? And the answer is probably no, either way. It's probably within the bounds of judgment either way. Nick's position is that Colorado statute doesn't have the non-severable unconstitutional person position that Minnesota anti-SLAPP had law. Well, if that's true, Scott, then that resolves the tension. If that's true, that resolves the tension. If I understood Nick's criticism, and this is why I went to some pains in my discussion to say, like, I don't know if I completely understood Nick's position. I was like, I'm not sure if I'm getting this right, because I just understood it very vaguely. But if Nick's position is a more nuanced position, which I didn't understand, then I would obviously change my analysis. Changing facts changes analysis. So if Nick has the position that Minnesota's version is unconstitutional, but Colorado's is not, because of some part of the statute, then that would be fine, right? He wouldn't be a hypocrite then, because he would be distinguishing it based on a factor that would be understandable. So it would be yeah. There's different versions of the same statute that might be constitutional or not, right? So for Nick as a lawyer to take the position that Minnesota's version is unconstitutional, so but Colorado's is not, is at least philosophically tenable. So if Nick's position wasn't, I don't like anti-slap in general, if that wasn't his position, but rather I dislike certain versions of anti-slap specifically for this particular reason, and that particular reason was true of Minnesota but not Colorado, then there's no hypocrisy, right? At that point, Nick is just taking a nuanced position. And nuance isn't hypocrisy as long as you're willing to apply it universally. Nuance is not hypocrisy as long as you're willing to apply it, universally. So then my question would be whether or not he my question would be whether or not that's a recent development in his philosophy, right? So is it the case that he always had this nuanced position, well before this lawsuit ever came to be, well before, this was ever contemplated in anyone's mind? He had this position where he's like, I only dislike anti-slap statutes that have this kind of problem. Minnesota's version has this kind of problem. Therefore, Minnesota's version is unconstitutional. And he would have taken the position that Colorado was always okay. So would he have always made this distinction, which is one version of reality? Or did he take the position that only as a result of this? So only as a result of this lawsuit, he's taken the position. Then the next question is, assuming that he's only taken it because of this, the next question would be whether or not he's truly been convinced he was wrong in the first place, or whether or not he's engaged in special pleading, whether or not he's taken the position merely because it's convenient for him right now. So has he truly been reformed, as it were, and truly seen the error of his ways and like, oh, I was wrong. Now that I've seen the light, I'm willing to apply this universally, and I was always wrong. Or is he merely adopting it because it's convenient? So which of those realities are we in? So hopefully that is all clear as I try to very nuancedly critique this, because I'm trying to engage in a lot of nuance too. So I'm like, so did he adopt it before or did he adopt it now? If he adopted it now, was it for this reason or for that reason? So lots of nuance along the way, right? As I try to figure this out. So, and I want to make clear again that I stated from the very beginning that I didn't really fully understand Nick's position. I just had understood him because I listen to Nick sometimes, as I do, because he's my friend, and hopefully will continue to be my friend. I had understood him to be opposed to it, but I didn't understand exactly why. So I'm like, is there a problem here? Is there a problem here? And why is he taking this position? It seems a little, there's a question in my mind, is it this or is it this or is it this or is it this or what's going on here? And so all the rest of it. And so maybe Nick and I can talk about it. We'll have a stream together and he can explain to me all this or not, or he can, use this entire discussion as a response in his stream or whatever. So I've given him lots of material to talk about if he wants. So I also look forward to everyone flooding Nick with DMs just saying, Kurt is just raking you over the coals. Kurt is just uncivil, is just destroying you, Nick. Uncivil, absolutely destroying you and raking you over the coals. What a slap fight he's having. What a rah blah blah. And just like, destroying all nuance and all this discussion. And yeah. I look forward to the 3,000 DMs that Nick is probably getting right about now. That's great. Lord have mercy. All right. So anyways, pressing on. Nick's special motion dismisses denied. First is denied with regard to count 1 because Colorado doesn't apply in this present case. which, fair enough. It would make sense that Colorado could apply in the first instance, by the way. So, by the way, in case we want to discuss it just for more legal edification, by the way, about why Colorado law could apply, as long as we're doing legal education, why not? The reason Colorado law might apply is because this is an intangible harm, right? And so we deal with the situs, as we say in law, the situs of the harm. And so the situs of an intangible harm, such as defamation, is often thought to be the place in which the person who's being defamed is being hurt. So I'm assuming Quest lives in Colorado, because otherwise this doesn't make any sense. So Quest, I'm assuming, lives in Colorado. So Quest's argument for why Colorado law, apologize, because Quest wants it the other way around. Nick's reason for saying that Colorado law should apply is that Quest lives in Colorado. The situs of the injury is Colorado. Therefore, Colorado law should apply. And Quest's argument for Minnesota is that is where the defamation came from. It's where Nick lives. It is not unfair to him to apply the law to his state. And also, the state has said at least some version of this is unconstitutional. And apparently the Minnesota court here is not willing to make this distinction that Nick is trying to make, maybe, and all the rest of it. So that's why their respective positions are the way they are. And the court here says Minnesota law on this conflict and choice of laws issue, which makes sense, but that's why they're taking the positions they are. So that was way too much legal education right now. Yeah, that's all that stuff. So that's why they're taking those positions. Oh, and then John Doe says he might have lived in Colorado, but suddenly changed his address to Illinois. Yeah, I vaguely remember that occurring on dispute about where does he live. Well, I suppose it would be, I suppose the correct place would be the time of the injury occurring. So where he lives now is kind of, where he lives now would be immaterial. The question would be where he lived at the time of the injury, because obviously the injury occurred at a time in a place where he lives somewhere. So whether he lives in Illinois now is probably not material either way, right? It's probably not material whether he lives in Illinois, because the question would be the situs of the injury, and the injury occurred when Nick said it, if it did. And if he lived in Colorado at the time, then the situs of the injury would be Colorado, even though he lives in Illinois now. By way of comparison, it would be like having an automobile accident in Colorado. The situs of the injury is Colorado. Where he moved to doesn't change that. Where there's a choice of law issue in Minnesota, the court must first find a conflict, which, and then did 5 choice, fine. Most of the factors apply in Minnesota law. In Minnesota, accusations of P-word are traditionally treated as defamation per se, fine, and tested by the reasonable person standard to understand whether a reasonable person would understand the accusations as truthful. Or more to the point, statements of fact, because statements of opinion can't be true or not. So accusations as truthful is probably not, I guess truthful is technically correct in best kind of correct, because if it's so absurd as to not be believable, then no one would understand them to be true, even though they purport to be statements of fact. So I suppose understand them as true is correct, because if the person listening to them understands them to be false in the first place, there's no injury. If they understand it to be so absurd as to not be true, it can't be understood as truthful, so there's no injury. So I suppose technically correct is the best kind of correct. Truthful is the correct word here, so fine. The standard is treated as a question of fact for a jury that cannot be decided on summary judgment. Therefore, they're not entitled to summary judgment. Neither is Rekieta entitled to summary judgment on intentional infliction of emotional distress. They must show injury at the stage of litigations is premature and maybe later. Okay, all that stuff. So I understand this. This makes logical sense to me. This isn't necessarily to say, by the way, for the record, just so that I'm clear about this, that I necessarily agree with the court's decision. I am not taking a position right now as to whether or not I agree with it, but I am taking the position that it's legally viable. I'm also taking the position as hypothetical court of appeals that I don't think there's anything I can do about it. Because even if I were to disagree with the trial court, that doesn't necessarily mean I can do anything about it as a hypothetical court of appeals. Because the hypothetical court of appeals is going to view such things under standards such as, for example, abuse of discretion or clear error, neither of which appears to be manifest at this time. So or just, the only thing you could try to de novo this on is the issue of which law should apply, I guess. But I don't think the court is necessarily wrong there either on that analysis. So, as hypothetical court of appeals, whether I would agree with this or not, I don't think there's anything I can do about it because it is a legally viable decision, even assuming the complete opposite decision would also be legally viable, which is a distinct possibility. Because courts get discretion, and that discretion can sometimes go both ways. And, just for the sake of absolute clarity, by the way, as always, I would discourage you from contacting any of the parties in this to harass any of them. That is not befitting of people. These people, there's no cause to harass anyone. And so I don't know Steve Quest. I don't really know much about him. But please don't target him for harassment more, because there's no need for that. Duncan says, even if I were advocating for myself, there's a difference between the world and laws as I think they should exist, and a world and laws which actually do exist. I think that's generally true. I'm not sure it's true in the specific case where you're invoking the protection of the law you disagree with. I'm not sure if it's true in that specific situation. It's like people who call for more taxes but do everything possible to avoid paying their own taxes. It's like people who call for more housing for the homeless but do everything possible to prevent that homeless property from being developed because it hurts their personal interests. It's I'm not really sure that distinction exists when it comes to advocating for one thing for everyone else. Rules for thee and rules for me suck. Rules for thee, but not rules for me blows, is basically what I'm trying to say. Rules for thee, but not rules for me blow. And so if you're like, the rule should be no slap, and you don't have to invoke it, which you don't, right? You don't have to invoke it. It's like sovereign citizens, when they go to, it's like sovereign citizens when they go to appeal or something, right? Or sovereign citizens when they say, I want the protection of the Constitution. The very thing that I disagree, I have the right of due process because the Constitution protects me, even though I don't believe in the Constitution because I'm not bound by it, right? It's trying to have your cake and eat it too, and I don't really like that. It's bullshit. I don't like it when sovereign citizens do it. I don't, I think there's a difference between understanding there's a reality that you don't like and invoking the protection of that reality because it just happens to be convenient for you when you don't have to. It's like, how much do you really believe in this, right? How much do you really believe in it? It's like everyone else should do something, but I don't want to give it up. Who's going to be the first to drop? Who's going to be the first to drop it when, all that. So, yeah.